Hello, friends. Father Frank Pavone here, National Director of Priests for Life. Welcome to our program as we continue to explore the Supreme Court case called Dobbs versus Jackson's Women's Health Organization out of Mississippi. This most important abortion case in decades, and we're going to be in this series of programs explaining why, and specifically looking at the arguments that are being presented to the court alongside the arguments of the state of Mississippi itself, which, as you know, passed a law protecting babies from 15 weeks of pregnancy forward. Others have come to the court, friends of the court, as we call them, and presented supporting arguments in favor of Mississippi's position. Well, today we're going to talk with one of our colleagues and friends in the pro-life movement representing Americans United for Life, one of the most respected legal organizations within the pro-life movement. Katie Glenn is the Government Affairs Counsel for that organization. And we're going to talk about two briefs that she worked on that have been submitted to the court, and we'll get into the details. Katie, welcome to the program.
Great to be here.
So you've been busy. AUL has been busy. We all have, as the Supreme Court has accepted this case. And I want to talk about first the brief that Americans United for Life as an organization submitted to the court, and then this a much longer brief, substantial arguments presented by 228 members of Congress. And you, of course, and others at AUL facilitated that brief too. Powerful arguments. I love both of these documents. And let's start, though, by just kind of backing up. AUL has been at this a long time, haven't you? It mentions it at the beginning of your brief that you've been submitting briefs in how many Supreme Court abortion cases? Quite a few.
That's right. AUL was founded in 1971. Sorry, my cat is joining us. Before Roe v. Wade, and it was started by a group of attorneys in Illinois who worked really hard in a case in that state to get guardian ad litem status for the unborn child. So in Roe v. Wade, we know the interests of the woman were supposedly presented, the interests of the state was presented, but nobody was standing up directly for the child. That's something that a group of attorneys in Illinois decided they needed to do. And once they were done with that in Illinois, they, said, we need to take this nationwide. And so they founded Americans United for Life. And for the past 50 years, that's what we've been trying to do, is really represent the child in these cases. So we have either played a party or filed a brief in every case at the Supreme Court since Roe v. Wade. And we filed two cases, as you mentioned, in Dobbs.
Yes. And, I often point out to people, those who follow the abortion issue know Roe v. Wade and perhaps some of them know Doe v. Bolton. But I'm constantly pointing out to people the Supreme Court has actually ruled on abortion dozens of times since then. And each of these rulings has had one or another effect and overall has weakened Roe. And this case now, of course, stands to weaken Roe even further. As you know, the main question that it's presenting and analyzing is if a state, let me just rephrase it, if a state passes a law protecting babies in the womb before viability, should that law be considered automatically as unconstitutional? That's the question before the court. Katie, this brief from AUL, basically it makes me think about the New York Times headline the day after Roe v. Wade: Supreme Court settles abortion. And as we know, not only from legal arguments, but just from experience living in America, it is one of perhaps the most unsettled issue in our society. Supreme Court didn't settle anything, but AUL makes a very, very precise legal argument that this is an unsettled decision, not only Roe, but the 1992 case of Casey, Planned Parenthood versus Casey, that these are unsettled decisions. Tell us, Katie, first of all, what that means legally, And why is that an important argument to the court at this point in time?
Well, you're absolutely right. Both the Supreme Court justices who decided Roe, as well as the New York Times and so many elites in our country, wanted the discussion to be over. They knew they couldn't win in the legislatures, and so they went straight to the court. And as you said, the New York Times said this is settled. However, we argue in our brief that this issue is radically unsettled because 50 years later, we're still talking about it. We're still arguing about it. And so in our brief, we really go into the details of that. The fact that the justices have never really seemed to agree on the constitutional grounding. What part of the Constitution gives us a right to abortion? The word's not in there. And even, pro-abortion stalwarts like Justice Ruth Bader Ginsburg have repeatedly said things like, well, I would get there a different way. I wouldn't have done it the way that these justices did. So there is not a strong foundational basis for abortion in the Constitution. There never was, and there certainly isn't now. And we saw questions about this even during the confirmation hearings of Justice Barrett, where, she was being asked repeatedly about Roe, and they said, do you think this is super precedent? And she said, the fact that you're asking me these questions suggests that it's not. You aren't asking me questions about Brown v. Board. You aren't asking me questions about Marbury versus Madison. You're asking me questions about Roe v. Wade because this is still up for debate. And so whether you look at polling, whether you look at scholarship, this issue has not settled. It never was. And that was the great folly of the justices. They tried to force a mandate on Americans, and for 50 years, we've said no.
There's a distinction. I do want to get a little bit technical here. There is a distinction in the brief between something that is precedent and something that requires the respect, the stare decisis respect, as the brief says. In other words, to say, let me try to translate this, and then, of course, you expand upon it. It's one thing to say that the court ruled a certain way in the past. That's precedent. It made a judgment at some point in the past. It's a different question to say we should continue with that same judgment, right? Isn't that the distinction that's being made here? And if so, what is it then about the precedent? I mean, aside from what you've already said, that the brief argues, but this doesn't deserve the kind of respect to say we ought to keep reaffirming the same judgment.
You're right. So stare decisis is a Latin term that means leave things settled. So the court has made a decision, and unless we have a good reason to change it, we'll leave it settled. And the reason for this is primarily so that the American people know what the law expects of them. They know what is expected, if they take that into other contexts, and certainly that they won't go breaking the law because they're unclear of what it says. So the point of stare decisis is that people have notice of what's expected. However, there are factors that we lay out in our brief, such as faulty reasoning, new information. In Roe v. Wade, Americans United for Life filed a brief that provided medical evidence, but the parties to the case really didn't. That wasn't an issue because the case was based on a standing question: who can sue to challenge the Texas law? It wasn't about the right to the unborn baby. So these are the kinds of things that we are arguing need to be brought into court. And that's what Mississippi said. We have to be able to bring in information like gestational development, like the fact that fetuses feel pain much earlier than 24 weeks, which is the accepted viability line of the 1990s in Casey. And even the fact that viability now is closer to 21 weeks, and babies routinely are born and survive at 21 or 22 weeks. So that's even earlier than what the 1990s court would have anticipated. These are all factors that go into the reasoning for why the court would revisit a decision.
Does this intersect with what the brief says about, and this is an astonishing phrase, that these cases are unsettled for the reason that there was no evidentiary record behind Roe v. Wade? Tell us what that means.
Yeah, so it's as simple as, if you watch any legal procedural show, you watch them go through a trial. That never happened in this case. There were some brief arguments made at the district court level, and they went straight to the Supreme Court because they were arguing to the court over who should be able to sue and challenge the Texas law and what that might look like. However, you had these activist judges who were determined to answer this question, to take it to the end. They didn't want to hear arguments. They didn't want to hear medicine. And so they picked this case. There's a reason that the justices on the Supreme Court picked this case, is because they didn't want that record. They didn't want to have to fight against it. They barely even wanted parties who were making constitutional arguments about abortion. The parties were making arguments about who could sue. And so they were able to then take that total lack of information, fill in the blanks. And that's why you've got a case that's built on such faulty ruling, because they didn't go through the normal court process that we think of.
The history is bad, the medicine is bad, and certainly any attempt at constitutional reasoning is bad, to sum it up, right? One other thing before we go to the second brief, and by the way, for those that are joining us now, brothers and sisters, we're talking with Katie Glenn from Americans United for Life. She serves as the Government Affairs Counsel, and we're talking about two briefs that she helped to prepare for the Supreme Court in this current abortion case called the Dobbs case. So, Katie, in this brief, two more things to briefly comment on. Number one, it makes a great point that one of the reasons Roe and Casey are so unsettled, or one of the pieces of evidence that they are unsettled, is that the states themselves have rejected them. And I'd like you to explain what that means. And then also, besides this, most of the states rejecting the Roe and Casey framework, the other place where we see this so unsettled is judicial criticism. Judges both on the Supreme Court in their various dissents over the years, but also in the lower federal courts, really taking aim at Roe v. Wade and saying, this is flimsy, this is unpersuasive. Tell us about both of these areas.
Yeah, from the very beginning, from the moment that Roe v. Wade was handed down in 1973, lawmakers said, we're not going to accept this. And so you had, lawyers like AUL attorneys long before my time. You had state attorneys general and governors all saying, how do we solve this problem? How do we regulate this? Because we are not going to live in a world where we have abortion on demand through all 40 weeks of pregnancy, not in our state. And so you saw lawmakers pass gestational age limits. You saw them pass things like informed consent. You need to get a basic medical information from somebody who's not financially incentivized that you get this procedure done. Things like parental involvement. The parents have to sign a waiver to give your kid a Tylenol at high school, but she could go to Planned Parenthood and get an abortion without her parents knowing. Or, California is trying to say that your parents' insurance should cover it, but you don't have to tell them what it is. They just get this mystery bill. All of these things were unacceptable to lawmakers. And so they spent, decades figuring out what kind of laws can we pass, what kind of limits can we set. And that's why we continue to go back to court, quite frankly, is because every time a state comes up with a new idea for a way to limit abortion, the industry sues, and we have to go all the way back to the Supreme Court to determine, how does this fit within Roe? How does this fit within Casey? Because in 1973, the Supreme Court said, we are going to be the arbiters of this issue. And so you do see a lot of criticism of that from justices, particularly, and judges, particularly from some of the new Trump appointee judges who are originalists. They say, we're looking at the text, we're looking at the context from when this law was passed or when this decision was made. It's clear abortion is not in the text of the Constitution. It's clear that these cases, tie judges in knots. And so we're increasingly seeing judges actually call on the Supreme Court to revisit it from their own decisions. Judge Ho in the Fifth Circuit had a great opinion in this very case where he said, our hands are tied because of the viability standard, but the Supreme Court has to act. We saw some judges on the Eighth Circuit do the same thing earlier this year related to Down syndrome, where they said it is obvious that prohibiting abortion on the basis of Down syndrome throughout pregnancy violates Casey, it is also obvious that this is a genocide on people with Down syndrome, and the court has to let us do something about this. So we are more and more seeing judges really speak out about the damage that this decision has wrought, and we hope that the Supreme Court will listen to them.
So the brief of AUL to the Supreme Court saying, hey, listen, this is unsettled. Don't think about this as settled law, and therefore it doesn't deserve the respect of being reaffirmed and reaffirmed. You've got to re-examine it, and you really do have to overrule it, throw it out, and let's get on with a more sane policy. Now let's look at the other brief that you were involved in preparing on behalf, and this is really historic because I understand that this is the first time that such a large group of members of Congress, 228 of them, 44 senators, and the rest, of course, members of the House of Representatives, almost half of both bodies of Congress. The first time that such a number have together gone to the Supreme Court and asked them to reverse Roe v. Wade. So this is a just with that alone, an historic moment that people need to take notice of, isn't it?
Yeah, absolutely. We were messaging this from the very beginning to members saying, like, don't miss out on this. You have to get your voice heard. This is the time to get off the sidelines. We know you're good on judges. We know that you're going to support Born Alive, but this is a chance in unison to bring your voices together and to say to the Supreme Court, enough is enough. Like, hand authority over lawmaking back to lawmakers. So we're really glad to have leadership in both the House and Senate get on board, help get their colleagues on board. And I've got to say, our total number of pro-life members was 231. There were 3 senators who filed their own brief, making a little bit different of an argument. So total, we got 231, which is the most members to sign on to a pro-life brief since Harris v. McRae in 1980. So that was a huge accomplishment and a huge message to the court that the Senate and the House are really speaking to this issue and saying, like, give us that power back. We can make laws. We don't need you to do it anymore.
And Katie, these were Republican members of Congress, right? There weren't any Democrats that signed on to this, were there?
Unfortunately, it was all Republicans. We filed a brief 2 years ago for members and had 2 Democrats join us. Both of them were voted out in 2020. We think that everyone should agree with this position. We think this is, and the American people do. It's just that a lot of members of Congress, unfortunately, don't. But, as we see in some of the briefs of state lawmakers, there are many more Democrats at the state level, unfortunately, than in Congress.
The closer you go to the grassroots, the more pro-life Democrats you find. In other
Absolutely.
words, yeah, it's true. It's true. I see the same thing. When I started, just as an aside, when I started leading Priests for Life in '93, there were dozens of pro-life Democrats in the House of Representatives. We worked with them, and now they've disappeared. Of course, Henry Cuellar from Texas, he recently voted against that radical abortion bill in the House, but he was the only one. He was the only one of the Democrats that voted against it. So, so go into this brief. I want to read a sentence here. Beautiful, beautiful, right at the beginning of the brief. It is long overdue, these members of Congress say, for this court to return lawmaking to legislators. Now, that's a clear and powerful statement. And to summarize, and then, of course, you can explain this more, what this brief is saying to the court is, look, we are lawmakers. And we know the role of a lawmaker. We take into account the circumstances of the people that we serve. We have hearings, we listen to evidence, we take account of the changing facts in society, and then we make laws that are best going to serve the needs of the people. What the court has done by insisting, and again, we remind our listeners, the court is looking at the question, if you protect babies in the womb before viability, does the fact that it's before viability make that law unconstitutional? So here we have now this big group of federal lawmakers, and many of them did serve as state lawmakers before, saying, look, when we make law, we take account of a lot of different facts. If a court is going to strike down a law, then the state, in order to defend it, needs to argue those facts. We need to bring to the court the reasons why we implemented the law in the first place. Like Mississippi, okay, they protect babies at 15 weeks going forward, and it gets challenged in court, and they say, well, look, we have reasons to pass this law. Things have developed in medicine, as you, Katie, already mentioned. We have more and more evidence that abortion harms women. We know who the baby is. We know the baby feels pain. We know that the abortion procedures are horrific and barbaric. And we also want to protect the medical profession, the integrity of the medical profession, being a profession of healing that does command respect. We don't want this to be looked at as a barbaric killing industry. So these, and of course you can explain more, these are some of the specific interests of the state, some of the motives for which they would say no abortion even prior to viability. But what these Congress members are saying is, if the court just says, look, we can only prohibit abortion, the state may only prohibit abortion after viability, anything before that, it's like the court is doing this, right? They're putting their hands over their eyes. They don't want to see anything. They put their hands over their ears. We don't want to hear anything about why you passed this law, about the medical evidence, a harm to it. We don't want to hear any of that because, after all, it's pre-viability. So, case closed. Now, hasn't that been the problem? And isn't this what these members of Congress are arguing against?
That's exactly it. And you laid out really well all of the arguments that Mississippi made. And so we really tied the federal interests into those as well. Right now, your laws are only as good as what you can defend in court or keep the opponents from suing you on. So, half of the states don't limit abortion around viability because that's where they think the best place is. They do it is because that's what the court has told them they can do. And, another 20 states limit abortion at 20 weeks based on fetal pain, something that Mississippi argued for as well at their 15-week law. These are laws that would be struck down because 20 weeks is clearly not viable, but the other side hasn't sued because they don't want the court to hear these interests. They don't want the court to consider things like fetal pain or the significant increase in complications and dangers to women's health. They don't want those arguments to be made. They want the judge to do exactly what the district judge in Mississippi did. And we've seen all over the country where they say, viability is the standard. 15 weeks is clearly before that. Case closed. We're done here. That's what they want because that's the only way they can win. They can't win in the legislatures. They can't win when we're able to bring in all of these other compelling interests, when we're able to bring in science and facts and medicine. They won't win. So they have to hold tight to this viability test because that's the best they can do.
It answers the question that the grassroots pro-life person has. Look, we know so much about the baby. It's so clear this is a life. Why don't they get it? Why don't they get it? Well, this is one of the reasons they don't get it. They're not even allowing the evidence to be considered. Why is it that, when President George W. Bush signed into law back in 2003, the partial birth abortion ban, and then 4 years later, the Supreme Court upheld that law in the Gonzalez case. Why is that helpful and instructive? I know that you bring that up in this brief. Why is that instructive to the court for the argument Congress is making here?
So we cite that as an example of an opportunity where, Congress passed a law banning barbaric, horrific partial birth abortion, where they literally start to deliver the baby and then kill it. And the Supreme Court allowed the state to make arguments. They allowed the state to bring in evidence of why, as you said, this takes medicine from a healing profession to a killing profession, on why it is so horrific to the baby. They got to actually speak about the procedure itself in court. And so when the state got the fair shake to defend its law and they got to actually make these arguments, they won. And that is terrifying to the abortion industry. So we cite that as an example where the state got to go through the proper process, what we think of as actually being a trial. They weren't shut down. They could make their arguments and they won. there are times where I might not like it, but the state's going to lose, but at least they get a fair process. And they haven't gotten that since Roe v. Wade.
A final point. I mean, and this brief again is so good. I'm encouraging our audience, Katie, to read all these briefs because aside from obviously the value of supporting the arguments in court, this is such a tremendous public education right now about all the reasons that Roe v. Wade is wrong, and that abortion itself is wrong. So I want to thank you again and commend you for this, the hard work that went into this. But one other point about what the brief says about viability. It's unclear in meaning and unreliable in guidance is a point that the brief is making. We don't know what viability means. And I mean, in the sense of being a clear a boundary line, even if one were to accept it, because it's dependent on so many different factors. And so the judges themselves are having difficulty, and not to mention the legislators, and again, these members of Congress are speaking as legislators, in how to apply it. But the brief says something here that I'd like you to explain to our audience. It says, both in Roe and also in Casey, the viability standard, in other words, to say you can only prohibit abortion after viability, is, quote, dictum. So that's a Latin word that means something that is said. Explain to us legally what is dictum and why is it not so powerful?
So when you read an argument from a court, whether it's one judge's opinion or the opinion of the court, all that really matters as far as that precedent, that what we have to follow in the future, is the holding of the majority. So everything else in the majority opinion is dictum. And as you said, it's something else. It's non-binding. So it can be instructive, it can be helpful, but courts are not bound to it. So, we talked a little bit a few minutes ago about how the court in 1973 was really spitballing. They're like, how do we create a ruling that does what we want, which was abortion everywhere, when it's not in the text of the Constitution and we don't have a firm legal basis for it? So they sort of came up with this idea of viability. It was a word that they found in a medical textbook, and they thought, there's some interest that attaches to this baby once it's viable or able to live outside of the mother's womb. But when it's before that point, when it's still, has to continue living in the mother's womb to grow and develop to eventually be viable, it doesn't have any rights. That's really what they said. And that's something that is just completely unable to stand up to emerging medical technology, to advancements, even to things like ultrasound that show that this baby is living and breathing and developing and growing. And so that's something where, there's been so much ink spilled on this word of viability, but that was not the holding. That was simply something that was made, an argument that was made in the decision that we've really firmly attached to. And I think it's time to reject that framing.
To sum things up, I'm quoting from page 10 of the brief here. It says, Casey, and of course we can say the Supreme Court, period, never offered a principled explanation of why the possibility of maintaining and nourishing a life outside the womb changes the strength of the state interest. And the state interest, of course, we talked about a few moments ago. Hey, we want to protect the health of women from harmful abortion. We want to protect a baby who's more clearly a baby than we've ever known before. We want to protect the medical profession from being known as barbarians. And the state has interests. And Katie, didn't the court affirm that even in Roe v. Wade? The state has interests in protecting the health of the mom and in protecting even the life inside whatever one wants to call that life. And this was, of course, stated again in Casey. The state has these interests. And I think, you can sum up what these members of Congress are saying by saying, hey, let the state exercise these interests. Don't say the state has the interests, but then hinder them from acting on it until after viability. And that's it in a nutshell, isn't it? This argument that this brief is making.
Yeah, that is completely it. It's giving the state the opportunity to step in and, quite frankly, to be the only one stepping in on behalf of that baby. certainly doing a better job in our estimation of protecting the interests of women in society. But the state right now is the only one who is stepping in and protecting that child. And, fundamentally, it's never going to make sense to the average American, nor should it, that at 23 weeks and 6 days, you are completely expendable and you can be killed in a horrific way. But at 24 weeks, it's that magic number, and that's how you're protected. This is something that hasn't made sense. It's not going to. And that's why we have to keep fighting against it. And so I really encourage, all of your viewers, as much as, you can read some of these decisions and really educate yourself, keep going to the March for Life, keep speaking up, keep counseling on sidewalks, because that is how all of us as, the American people can say, this is not settled. I will not agree to this. And I think, the court is going to be looking at lots of different sources of information, but certainly how we say we're going to stand up in a post-Roe world is going to be one of those.
Katie, it's always a pleasure talking with you. Friends, we've been chatting here with Katie Glenn from Americans United for Life. She serves as a government affairs counsel, and there are certainly a lot of things going on in government in regard to this issue these days, and we're all happy to be part of this battle. I want to encourage all of you friends to read these two briefs that Katie and I have just discussed. And Katie, I want to give our viewers another little action item here. Thank your representative and thank your senators who signed on to this brief. They deserve your thanks. They deserve to know that they signed on to this, that they're raising their voice to the court, saying overturn Roe. It makes no sense. Viability standard makes no sense to stop states from protecting these babies. Thank them for doing this. It's an act of courage. It's a public stance. And again, sadly, there were no Democrats that signed on to this. And I think we have to be clear about this. When it comes to Congress, this is a partisan divide. It doesn't need to be, but it is. And but nevertheless, the arguments here are solid and sound. And friends, we need to understand those arguments, which Katie has helped us to do here. And we need to echo them to our fellow citizens as well. So Katie Glenn, great to talk to you as always. Thanks for being with us on this program.
Thank you.
And friends, continue to join us as we explore the other briefs, many of them that have been submitted for the pro-life side in the Dobbs case. We'll be continuing to do that with so many of the great leaders, legal experts, and pro-life organizations across this nation. Meanwhile, go to SupremeCourtVictory.com. You'll find the links to the briefs there so that you can read them, the links to the interviews that we're doing. And also you'll find there the prayer campaign to ask God for victory in this particular case. SupremeCourtVictory.com. Thank you, brothers and sisters. Father Frank Pavone here of Priests for Life. We will talk to you soon.